अकोला बार असोसिएशनचे स्टडी सर्कलचे जे पदाधिकारी आहेत, तसेच अकोला बार असोसिएशनचे पदाधिकारी यांचं सर्वात पहिले मी अभिनंदन करतो की त्यांनी हे स्टडी सर्कल कॉन्सेप्ट सुरू केलेला आहे. खरं पाहिलं तर आम्ही जे जनरेशनचे आहोत, आय कम्प्लिटेड माय अँड जॉईन द बार इन 1996. अँड आम्हाला जेव्हा आम्ही जॉईन झालो ते एक कॉन्सेप्ट आला होता, जसं तुम्हाला आता एक्झामिनेशन आलेलं आहे. दॅट वॉज कॉन्सेप्ट दॅट वी हॅव टू be a junior without sanad. To obtain the sanad, you have to be a junior with a senior who has completed 20 years of practice. And subsequently, that was cancelled by the Honorable Supreme Court. त्याच्यानंतर एक वर्ष आम्ही त्याच्यात वाया घालवला. पण तुम्हाला एक अपॉर्च्युनिटी भेटलेली आहे की सनद घेतल्यानंतर यू आर ट्राइंग टू बी अन ॲडव्होकेट and you are also getting an opportunity to appear for all the exams and every competitive exams for judgeship and everything. So we are a unique generation in the sense that we have also used telephones, we have also used pagers, we have also used the mobile phones, that is the touch mobile phones also, and mobile phones which were simply different. And as far as the system is concerned, Akola Bar Association is concerned, we have seen the typewriters. एक कॉन्सेप्ट असा होता की 1+2 पेज लावायचं, मग ते शॉर्ट हँड मध्ये डिक्टेशन घ्यायचे. सिनियर इथे टायपिस्ट होते ते डिक्टेशन घ्यायचे आणि सिनियर जे होते ते डिक्टेशन द्यायचे. हे कॉन्सेप्टच्या नंतर पहिल्यांदा कम्प्युटर आला. कम्प्युटर आल्यानंतर पहिले सुरुवातीला जेव्हा मोबाईल आला तर इट वॉज रिस्ट्रिक्टेड इन द कोड. आता असं झालेलं आहे की आपल्या साईड लोकांचे जे डायसवर आहेत ते त्यांना आवश्यक झालेलं आहे सर्व मुद्दे. तर आय थिंक वी आर अ युनिक जनरेशन दॅट वी आर सीइंग द ट्रान्झिशन from extreme to this mode which we are here. Now we are also using iPad and everything, and all the judgments are on our fingertips. In our juniorship, there was a special class also or instruction, especially Mehere sir, now retired justice. He used to very wonderfully explain to us how to search the citations. I don't know how many of people have been taught how to search a citation on a particular subject, because now search facility is available. Earlier only books used to be available. So I think we are very lucky enough that all these resources are available to you. Along with that, when all this is being provided by the bar, I think you should take the advantage of this. Now the subject which has been handed over to me is Mohammedan law. Whenever we are coming to the court and joining this profession, the word which is used that we are practicing. Every day we are practicing. Nobody is perfect to it. So I would not address myself that I am conducting a lecture on a particular subject. I am also a student, and I would request that we should keep this approach. Whenever, luckily, I was just going through a lecture. A senior advocate of the Honorable Supreme Court was reciting or telling about one of his colleagues that you should respect each and every advocate in the corridor. कि कल पता नहीं कौन जो है वो जज बन जाएगा. Maybe luckily enough there will be many people who are here or who are reciting or watching this video subsequently. I will have to be both before them. They will be judges, and all. Probably, God willing, they will be elevated to the Honorable High Court also. But I have practiced before the Honorable High Court also and before the Honorable Supreme Court also. One thing I have noticed and which I want to point out is that you should always remain a student. Even the senior High Court judges, they don't shy away to reach their hand and fetch a parrot. त्यांना याची लाज वाटत नाही की आपल्याला माहित आहे की नाही आहे. नाही ठीक आहे, ते प्रोव्हिजन ते बॅरेट घेतात. सिम्पल ऍक्ट्स ऑल्सो द 3-in-1 CRPC, IPC and evidence act is at their disposal. Even if they might have read it so many times. So my humble request is that we should never come to this conclusion कि मला सर्व माहित आहे. It will always be helpful to you. Coming to this subject, it is a very vast one, and the time which is provided and also the patience which is with the students, this time will not be suffice to complete everything. So I've just taken out some points which can be considered as salient features of the Mohammedan law. And what is Mohammedan law? What comes to mind when you say Mohammedan law or Muslim law? As you are aware that in India, the personal laws of every community are applicable to them as far as marriage is concerned. And I would like everybody to be interactive if it is possible. For what personal laws are? Hindus are governed by their own laws for marriage, inheritance, right? That's way, in the same way, as far as Mohammedan law is concerned, people professing to the religion of Islam are covered by the Mohammedan law. I will not go into the details which already we have gone through, probably what are the, from where the Islamic law is there, Quran, Hadith and everything. These things are, now the applicability of Islamic law. First of all, if you consider the difference, I would like to come to the basic aspect as far as succession is concerned. The basic difference, it will be very easier for you to understand if you consider the difference between Hindu law and Mohammedan law broadly. As far as succession is concerned, when you consider as far as Hindu law is concerned, there is a concept of Hindu undivided family. There is nothing like this in Muslim law. The property which is owned by a person is his own property. In Hindu law, it's ancestral property. Even if it is an earned property, whenever a person, all the legal has have the right as per the law on that property. In Mohammedan law, the right is absolutely of the owner of the property. You got my point? So the concept is, when a child is in the mother's womb, as far as the Hindu party is concerned, his right will be in the property. But in Mohammedan law, till the person in whose name is property is there, he will be the absolute owner. Now consider this point and we can proceed further. So he has got the absolute right to dispose of the property. He can sell the property to anyone. He can give the property to anyone. But he cannot will the property. For the purpose of will, because obviously what happens, what is the difference between will, gift? When a person is gifting his property, he is making him the absolute owner. When he is selling the property, his rights are diminishing and he is gifting it absolutely to the donee. But in the will comes into force only after the death of the testator. The person who is executing the will, only it comes into the existence after his death. These are the basic difference. So if we understand whatever questions are coming in the competitive exams, or even if some matter is before you, you will have to understand this basic difference. The right in the Mohammedan law is absolutely with the person. Once he dies, the right of the legal heirs will come in. So he can gift it, absolutely, but he cannot execute a will for the entire property. There is a particular portion that only he can will it for the 30% of his share. So again, because this is very typical of the Mohammedan law, there is no concept of joint Hindu family property in Mohammedan law. He is the absolute owner and he can gift the entire property. Now in continuation of the same subject, if we consider what is gift, there is a concept of gift in Mohammedan law that is called hiba. And what is hiba? And another salient feature of Mohammedan law is that all the aspects, there is a very important aspect is that documents are not necessary. Oral agreement, oral execution of some document is provided in Mohammedan law, and that is also acknowledged by the legal framework. Coming to hiba, Hiba is a person, when a person gives his property, entire property or some share of the property to any person, he can gift it to any person. There are three conditions. He should gift it. The person to whom the property is being gifted should accept it, and the possession should be transferred. For this purpose, oral execution is also permissible. Now, there is a deviation from the general law, because we have learned this, and it is a general perception also that all documents needs to be registered. So what happens? In Mohammedan law, it is not necessary. Then, when there is a oral hiba, oral gift, registration is not necessary. We will say that it is no document. So registration is not necessary. We are not required to pay any stamp duty on it. For this purpose, you will note down section 129 of the Transfer of Property Act. There is an exception which is provided. So as I pointed out, there are three things. Declaration, you should declare. Now, in all the aspects as far as Mohammedan law is concerned, marriage, divorce, gift, agreement, importance is given to witnesses. I will come to the concept of marriage also and dissolution of marriage also, and importance of witnesses. So he has to make a declaration that I am making the gift of so and so property to so and so person. That person should, before the witnesses, accept that gift. And lastly, the possession of that property should be handed over physically. These are the three basic requirements of a valid hiba. Now the question arises, what will be the record of this document? Because we are saying that oral is permissible. So they can write down a memorandum. That will be called as memorandum of hiba. On this, the recital of this will be recorded, but you are not required to pay any stamp duty on it. It is not required to be registered. There are several judgments on this point of the Honorable Supreme Court also. And as we were discussing, that there are some aspects as far as the questions are concerned which are going to be in the exams for JMFC or another competitive exams. So if you can bring to me some questions, I can give you the answers also, that for that they will be helpful to you. So once the three ingredients are completed, a valid hiba is there and it cannot be challenged. Hiba is irrevocable. There can also be hiba bil evers. This is when something is given, against that he will give you something back. Evers means something in that can be only an object, that can be a prayer mat or something like that. But we are not going to go details into various kinds of hiba. We are only on the point of concept of hiba. Now, again continuing about the oral aspects of in the Muslim law, we will come to marriage. Now, what is marriage? The difference between marriage in Muslim law and other laws is that this is a contract. This is a contract between two persons to enter into matrimony. And for that, they have to agree into the terms. That is a nikah nama. And beyond the general perception, we can write down all the conditions in a nikah nama. A model nikah nama is also provided. And at the time of marriage, the husband has to pay or promise to pay an amount at the time of nikah. It is a reverse procedure. They have to pay the amount. It can be paid immediately or on demand also. That is called meher. So as I pointed out, marriage is a civil contract. Now we had very luminous lectures before myself. There was also on the point of contract also. So all the aspects are considered when even if the marriage is a question of contract. So how there will be a divorce now? That is also provided as per the Mohammedan law. The marriage can be terminated both by the husband and the wife. As we are aware now that there is a Act of 2019 which has prohibited instant divorce. I think this question will be the most which will be asked in all the competitive exams. What is the punishment which is provided? What was the instant talaq? Talaq which was given instantaneously, because as per the Quran, the procedure of divorce, that is talaq, is provided that it should not be given instantaneously. The husband is required to give one talaq during one cycle, and purpose is that obviously all these circumstances coming to the purpose of giving talaq is some dispute is arising. असं तर नाही आहे की आज ते खुश आहे म्हणून तलाक दिलेला आहे, तसं तर होणारच नाही. So they should get an opportunity to reconcile. So the concept of reconciliation is given. Even it is provided that they should get some relatives from either side and have a sitting, make all the attempts. Then if it fails, they should go for second talaq and for the third talaq. So there was talaq-e-bidar. Now what is the word bidar? Which has been prohibited, which is not liked upon. But that was legal. Now, as per the new Act of 2019, that has been declared as illegal. Even it is punishable. Now, what has happened? That has given benefit to a lot of people. Earlier, what used to happen when there was a notice sent by a lady for the purpose of maintenance and everything, the husband used to reply, and along with that he used to give recitals of 3 talaqs, even if he was not aware of the consequences. I would not say that our brother lawyers would do that. And now the question would arise, how to reconcile now? So again, there may be many people who are going to say that this has not been proper, but this is the correct procedure which has been adopted now, that there should be an opportunity for reconciliation. Now, as the 3 talaqs have been declared illegal, even punishable, obviously they have to go by the procedure. Now, second question would come on, what is the procedure for obtaining a divorce for a woman? She can also get a khula. She can come out of the marriage by asking her husband to give me khula. For that purpose, she can give something to him. That can be the dower. Maher होती ते माफ करू शकते किंवा काही रक्कम तिला देऊन ते म्हणू शकते मला I want to get out of this marriage, and he will pronounce the talaq and will be. The best option is that they should give one talaq, which will automatically be finalized within 3 months of the pronouncement. Till the 3 talaqs and the complete talaq procedure is completed for 3 months, she will be entitled for subsistence allowance, and as per the agreement, he will be liable to pay all the amount to him. As per the new act, obviously the punishment of how many years are provided? 3 years. And it is a cognizable offence or non-cognizable offence? I think we should concentrate more as far as academics is concerned on this new act. And if there are any queries on that, I will be able to satisfy it. I will try my best to satisfy it. Now the third aspect is divorce by mutual consent, that is mubarak. They can mutually agree, uh, come together after following the due process. Conciliation process has to be completed. Only after that they can execute a document of mubarak and the marriage which was solemnized will be over. So these are the general concepts of marriage and divorce as far as Mohammedan law is concerned. So if there are any queries on this point, or should we proceed to the next topic?
Any party can file the petition for divorce?
Certainly, any party can file the petition for divorce under the Muslim Code. There is a special act which is provided, and that can be filed before the family court also.
Whether the wife have any other grounds on which she can seek divorce?
Obviously, that is also available.
What are they, if possible?
So again the question which my senior has asked, which are the grounds? In Mohammedan law, as I have started my explanation, this is an agreement. So for the purpose of breaking that contract, we do not need specific grounds. But as the law has developed, all the aspects of cruelty is not taking care and all these things, all the grounds which are available, they are also available. For that purpose, we do not have any special concept of a special law as Mohammedan law is concerned. Again, the doors of the family court, and if the location is there, family court is not there, we can approach the civil judge. Because what is happening? At times we need certain legal document to show that the marriage has been broken or it has been ended legally. Another aspect which is coming is that once the nikah is completed, or as far as Hindu law is also concerned, when Saptapadi and everything is concerned, those procedures are completed and then we go for registration of marriage. So obviously we can take benefit of that also. Now coming to the next topic, guardianship and heirship. And this is I am coming because I experienced this. Legal heirship certificate was there. The son had died due to cancer. He had brothers, wife, children, father and mother. But somebody had suggested, or whatever might have happened, the legalship certificate did not show the father to be the legal heir. That is correct procedure as far as Hindu law is concerned. But that is not the procedure for Mohammedan. When we are applying for legal heir certificate of Mohammedan parties, the father of the deceased will also be the legal heir. Coming to the connecting topic, as I started my lecture about the person owning the property is the absolute owner. So there is a concept that if one of the son or daughter dies before the father, his legal heirs will not be entitled to the share in the property. Did you get it? Predeceasson. आता आपण थोडंसं एक सॅम्पल घेऊ. एक माणूस आहे एक्स, त्याचे मुलं आहेत ए बी सी डी. आता एक्स हयात असताना ए याचा मृत्यू झाला. तर ए चे जे मुलं बाळ वगैरे आहेत त्यांना एक्सच्या प्रॉपर्टीमध्ये कुठलंही शेअर भेटणार नाही, बिकॉज ही इज द प्रीडिसेसर. आता याच्या मागचा जो कॉन्सेप्ट आहे, व्हॉट इज द कॉन्सेप्ट? प्रिन्सिपल काय आहे? प्रिन्सिपल असा आहे की तोपर्यंत जेव्हा तो वारला, हिज राईट इन द प्रॉपर्टी डिड नॉट अराइज ओनली. त्याच्या अगोदरच ही पास्ट आहे. And as I pointed out, because that is why I started my lecture on the point of the difference between the concept. तो मालक झालेलाच नाहीये तर त्याच्या मुलाला त्याच्याबद्दल काही बेनिफिट भेटणार नाही. Then there is an aspect that we want to sell the property of the minor. Who is the natural guardian? There is a difference in Mohammedan law that mother will not be the natural guardian to apply to the district court. Grandfather will have to apply. So these are the minor points which I am trying to point out, because most probably in the interview or in written examination, this may be a googly question. Naturally, the person who brought me the legal aid certificate might have gone to a lawyer. आणि त्यांनी आपलं रुटीन आजकाल एक जे सुरू झालेलं आहे, टायपिस्ट कडे जातात, याचा फॉर्मॅट आहे का, ते फॉर्मॅट घेतला आणि त्याच्यात टाकून देणार. म्हणजे अनफॉर्च्युनेटली आजकाल जे प्लिडिंगचं होतं, तर प्लिडिंगचं कॉन्सेप्ट आलेलं आहे, ते वकील आपण टायपिस्टला सांगतो, आणि आता AI आलेला आहे अनफॉर्च्युनेटली अँड फॉर्च्युनेटली. त्याचं त्यांनी ऍप्लिकेशन दिलं, त्यांनी बनवून दिलं, अँड the court also in the routine procedure granted the legal aid certificate. Now what is happening? The question is, the name of the grandfather is not there in the legal aid. And when they want to sell the property, he will have to apply. So that is the legal dilemma which I was facing. These are the concepts which I want to point out. Then again on the point of, I think as far as Mohammedan law is concerned, all of you are aware that personal laws, as far as Mohammedan law is concerned, it is not codified. What do you mean by codified? Codification of a law. लिखित आहे, पण त्याला एका सेक्शन मध्ये, एका प्रोसिजर मध्ये शासनाकडून करण्यात आलेलं नाही. जसं मोहम्मदन हिंदू लॉचं झालेलं आहे इनहेरिटन्स वगैरेचं, तसं मॉडर्न लॉ. पण आता रेफरन्स करताना द बुक ऑन बाय मुल्ला, इट इज प्रिस्क्राइब्ड अँड द सेक्शन्स ऑफ द रुटीन्स आहे, मोस्टली दे आर रेफर्ड एज सेक्शन्स ऑफ मुस्लिम लॉ. So if you want to study further, I think everybody should have the copy of Mulla's Principle of Mohammedan Law, and in the book by Mulla on Hindu law is also very vast and exhaustive. That is also should be read. I would again impart on everybody, request it, do read. Do not, as far as pleading, I am going beyond my subject a bit, but asking a stenotypist for a pro forma and filling up the names and everything, you will never learn from that. Because why are you writing this? What are the paragraphs? Why the cause of action should be there? Where the prayer should be there? All these aspects are missing. So we should understand under which provision. At times I have seen some juniors going around, की त्या साहेबांनी तर आम्हाला प्रोव्हिजन विचारले. हे अर्ज तुम्ही कुठल्या प्रोव्हिजन मध्ये करून राहिले? आता काही ऑनरेबल काही जजेस आहे आपल्याकडे, दे इंडल्ज विथ द ज्युनियर्स अँड देअर इंटेन्शन इज व्हेरी गुड दॅट ऍटलीस्ट यू शुड रीड. आता बेल ऍप्लिकेशन आहे ते कुठल्या अर्ज सेक्शन मध्ये केलेलं आहे? आता लिगल सर्टिफिकेट साठी त्यांनी जर विचारलं असतं की वाय हॅव यू मेड पार्टी, वाय हॅव यू नॉट मेड पार्टी टू द ग्रँडफादर अँड व्हॉट आर द शेअर्स, अनफॉर्च्युनेटली nobody might have known, because legal aid certificate is applications are made in a routine course. So coming to these are the general aspects which I have framed, and I think the subject is so vast, it cannot be covered in a short span of time. Each subject, if we are going to give, if we have to indulge in the subject of khula and go into the case clause, if we have to indulge into the subject of transfer of property in the context of hiba, it will be very vast and it cannot be covered. So I would suggest that we can have a question and answer session also, of some discussion. I am also a student of law subject to correction, and I would request that you should frame some questions. We can request all the seniors who have been here before me. You can frame the questions and give them an opportunity to answer it to them.
Sir, can you explain the number of witness of witness in the Sunni or Shia law? That is in the marriage procedure and also in the talaq procedure.
Yes.
How many witnesses required?
आणि मॅरेजचं एजमध्ये काही फरक आहे का अंतरामध्ये? जसं इथे इंडियन मेजॉरिटी ऍक्ट प्रमाणे 18-21चा क्रायटेरिया तसं तिथे काही आहे?
So first answering the query Madam has made, the Quran has specified that whenever you enter into any agreement with anybody or in any transaction, you should keep a witness for it. And they have provided that there should be 2 witnesses, male. If you cannot get 2 male witnesses, 1 male and 2 female witnesses. So that is the basic criteria. And now applying that same thing to marriage, you need at least 2 witnesses. But there is now the second part is age. Now again we are facing certain litigation also, because there is no bar as far as marriage is concerned in Mohammedan law. The question will be about purity and that point. But another aspect will come about the law which are prevailing, the law of the land, which will take precedence. And what is that? The POCSO Act. What has happened? There are certain, now they are getting legally married, but when the girl gets pregnant and goes for so there are charge sheets being filed and they are being prosecuted. She is a victim now. So considering all these aspects, as the law of land has been framed, the age will be according to the law of the land, and that will be beneficial also. Again, aspect not only for Mohammedan law, there is a practice also in some nomadic tribes about an earlier marriage. That has also been held to be legal, but law of land will take precedence to it.
Sir, in that period,
Yeah. So what is the purpose of iddat?
if that is like maintenance,
No. Iddat is maintenance, but what is about the iddat period?
in that period,
Let me explain to you. Let me explain to you. The period of iddat which is there, it is 4.5 months. And the purpose is that she should live separately, and but the purpose is that we should come to know whether she has been pregnant, she is carrying of either the divorcee, or in the case of the death of the husband also, she has to follow the iddat for 4.5 months. The purpose is because when the husband died, whether she was pregnant, so if she follows the principles of iddat, this period is sufficient to come to know whether she was pregnant, she is pregnant. So the rules, if it is there that she has been kept in isolation 4.5 months, she is not allowed to meet male relatives also, and all this aspect is for this purpose only, that future disputes about the child should not arise. So it appears for both, in the case of the death or in the case of the divorce also. They have to follow this procedure.
विडोच्या केसमध्ये
विडोच्या केसमध्ये झालं ना, म्हणजे पहिला एक आहे त्याचा मृत्यू झालेला आहे, तर त्याला इद्दत पिरियड पाळावा लागेल. That will come to 3 आता ते 4.5 महिने याच्यासाठी दिलेलं आहे की 3 मेन्स्ट्रुअल सायकल्स जे आहे ते दिलेलं आहे, त्याला 4.5 महिने स्पेसिफिक दिलेलं आहे. तसंच एकदा तिचं डायव्होर्स झालं तेव्हा पण त्याला 3 मेन्स्ट्रुअल सायकल्स दिलेला आहे, आणि पर्पज तोच आहे. आणि इद्दतचं पिरियड, देयर इज अ क्वेश्चन ऑफ डायव्होर्स, as I pointed out, she will have to follow the iddat period, and in that period she can reside in the husband's house also. He will have to take care of all her needs, provide the subsistence allowance. आता आजकल जे obviously all the concepts get mixed up, so obviously she is not going to reside there, so he will have to take care, he will have to pay the maintenance. आपण आता मेंटेनन्स वर्ड यूज करतो, त्या प्रत्येक 3 महिन्याचं त्याला मेंटेनन्स वगैरे द्यावं, ते एक सोबत देऊ शकतो किंवा त्याचा खर्च वगैरे घेऊ शकतो.
सेपरेशन ऑफ प्रॉपर्टी जी आहे त्याच्यामध्ये शेअर्स वेगवेगळे राहतात त्या मेन मेंबर किंवा.
आता ऑब्वियसली Mohammedan law has provided since its inception the right to the ladies also. The girl gets right in the property of her father. The concept is that she will get one share while her brother will get two shares. The purpose is the same as far as now Hindu law is concerned, because she is going to some other house, she will get some share from that property. So that is the concept.
सर वक्त प्रॉपर्टी बद्दल जेव्हा आपण एखादा दावा दाखल करतो कारण ती प्रॉपर्टी डेडिकेटेड कोणाला
आता वक्फ प्रॉपर्टी म्हटल्यावर काय आहे की वक्फ मीन्स व्हेन आय एम डेडिकेटिंग सम प्रॉपर्टी इन द नेम ऑफ ऑलमाइटी अल्लाह फॉर द पर्पस ऑफ सम चैरिटेबल पर्पस for some religious purpose. So obviously when I have given some property in the name of Waqf, a Waqfnama is executed. In the Waqfnama, all these terms have to be, for example, I have given one plot, I have Waqfed my one plot, so I will cease to be the owner. Then I will execute a Waqfnama and provide how that property will be managed. I want that a masjid should be constructed on that particular property. Then I will delegate that this property will be managed by 11 people, a committee of 11 people. It's very similar to when we are going for a charitable trust. It's very similar. But what are the differences? I will point out. Again, when I have delegated the property, that people will hold that property in trust. They will manage the affairs. For example, I have given my plot, I have given also some amount also, then they will collect and they will construct the mosque. The day-to-day affairs and everything, accounts will be managed by those people. The question which has come, who will sue or get sued? For that purpose, the concept is very clear. Again, when it is obviously it will be a juristic person. The concept of juristic person is clear, I think, with everybody. What is a juristic person? Who is not existing, who is not there physically. A company. A company is a juristic person. It does not have a form or anything, but it is there. It owns property. It employs people. It pays salary to everybody. It is a juristic person. But it is not in existence. So, whatever affairs of the company, who looks after it? There is a board of directors. And board of director will have to pass a resolution and take a decision by majority. And for this purpose, there are company laws. Now, considering there is a cooperative society, there are members of the cooperative society, and the aspect is governed by Maharashtra Cooperative Societies Act. Again, for the purpose of Waqf, it is governed by the Waqf Act. Now, this aspect of Mohammedan law is codified. There was an Waqf Act of 1995, and subsequently there is a recent Waqf Act also. We will not go into the controversy, but that is the latest Waqf Act. Now, as there is a special forum provided for charitable, we have to go to there is a special forum for Waqf also. The jurisdiction of the civil court is barred. When the registration is made as a Waqf, the properties and everything and all the affairs are governed and they are adjudicated by the Waqf tribunal. But there are 3 members. One of them is the judicial member, who is equivalent to the post of the district judge. Our tribunal is at Chhatrapati Sambhajinagar. Any clarifications on it? Because I like it that way only, because some doubts are coming and I can answer it. Because lectures, you have had sufficient of it in the college. And
law of wasiyat.
because wasiyat, I came before you came, we covered that point. A person cannot give his property by wasiyat or will. He can wasiyat only up to 30% of the property. If he has to will the entire property, he will have to obtain the consent of his legal heirs. And I have explained it. Again, I will point out that The difference is that he is not the absolute. He is the absolute property as far as owner of that property as far as Mohammedan law is concerned. In Hindu law, he is not there, the absolute owner. That is the basic difference.
आणि सेपरेशन मध्ये विडोचा शेअर पण मुलीच्या शेअरवर राहील.
Widow's नहीं ना, widow's means yes. That has to be calculated because on the sharer and all these aspects, that is a detail and that will take a different त्याचे शेअर वेगवेगळे आहेत, त्याचा भाव किती आहे त्याच्यावर it will depend on all those aspects.
वैसे एक सवाल है
जी सर.
कि अगर शिया सुन्नी अब जो है सब तबके जो है उसको इनहेरिटेंस का एक ही और एप्लीकेबल है क्या अलग अलग?
अभी इनहेरिटेंस का या कोई भी लॉ है तो शिया और सुन्नी, एज द सब्जेक्ट हैज बीन पॉइंटेड आउट बाय माय सीनियर, शिया और सुन्नी इनके लॉ अलग है. सुन्नी के अंदर भी स्कूल ऑफ थॉट 4 है, उनके भी थोड़े थोड़ा कहीं ना कहीं डिफरेंसेस आते हैं. हमारे वहां सबसे ज्यादा जो है वो हनफी यूज करते हैं. हनफी who are following the टीचिंग्स ऑफ अबू हनीफा. इसके लिए उनके टीचिंग्स के हिसाब से उनका थोड़ा सा डिफरेंस आएगा. शिया का थोड़ा अलग है, उसके अंदर कोई ना कोई कॉन्सेप्ट में डिफरेंसेस आएंगे. लेकिन एज फार एज लॉ ऑफ लैंड इज कंसर्न, जैसे अपना महाराष्ट्र का एरिया है, यहाँ पे शियास का कम है. शियास के अंदर दो और अपने वहां पे जो मिलते हैं, जो बोहरा कम्युनिटी है, दे आर द प्रोमिनेंट पर्संस ऑफ फॉलोइंग द शिया. लेकिन वो भी शिया का दूसरा एक सेक्ट है, दे आर कॉल्ड बोहरास, इस्माइलीज. दीज आर अदर पर्संस. I didn't touch that subject because it's so vast.
वास्ट है वो, और जनरली परवेज
जी.
वो इसलिए क्या है कॉलेज में भी जो है उसको एक्सक्लूड करा है इनहेरिटेंस.
नहीं, I can address to that also.
इसीलिए उसको थोड़ा कठिन करा है.
अभी उसमें ऐसा होगा कि जो चीज जैसे वेरी फ्रेंकली कॉलेज में जब हिंदू लॉ पढ़ाते तो बहुत कुछ सर के ऊपर से जाता है, क्योंकि वो डे टू डे यूज में नहीं है ना. बट फॉर माई ब्रदर, for my friends who were there, who are belonging to Hindu community, उनके लिए वो easy था. So they used to teach me Hindu law, and I used to help them with the Mohammedan law. क्योंकि day to day use में आप जो use करेंगे, जैसे I think I have experienced this, as आप लोगों ने भी experience किया होगा. When you come to the court, in our time we did not have more courts and everything. We used to have evening colleges. And ठाकुर सर will vouch to that. हमारे को आईपीसी पढ़ाने आते थे सीनियर देशमुख सर. उन्होंने पहले एक ही पीरियड लिए थे, बोला आई एम रेगुलरली इरेगुलर, बट ही वाज अ वेरी गुड टीचर. वो शाम के टाइम पे कॉलेज होती थी. सो आई वाज ऑन द पॉइंट कि आप जब किताब पढ़े और जब कोर्ट में आए तो इट्स अ वास्ट डिफरेंस. एंड व्हाटएवर ऑफिस और व्हिचएवर ऑफिस यू ज्वाइन, जो केस का फाइल आपको सबसे पहले अपने हाथ में आता है, मुझे लगता है जितने साल तक वो प्रैक्टिस करेगा और जितने साल जुडिशरी में जाएगा, प्रोसिक्यूशन में जाएगा, वो अगर उसने उसका कॉन्सेप्ट पूरी तरह से फाइल पढ़ लिया तो ही विल नेवर फॉरगेट. आई वाज लकी इनफ टू हैव अ गुड सीनियर एंड अ गुड ऑफिस आल्सो, सुभाष काटे सर's office. So he even taught us how to, when you go to the court first, to mark your appearance in a case, सबसे पहले उसमें क्या देखना है. So we had a senior advocate Karare sir, is no more now. He explained to me फाइल में सबसे पहले क्या देखना है, how to take the notes, and you should be aware कि पहली एप्लीकेशन आपकी कौन सी जाना चाहिए. Because obviously I am talking about the civil side. सिविल साइड में आपने जब देखा तो सीनियर्स का कोच साहब को भी काम करते देखे, उसके अंदर देशपांडे सर, सीनियर देशपांडे सर, वहां पे पहला ये है कि उसका जुरिडिक्शन प्रॉपर है क्या, वैल्यूएशन बराबर है क्या. तो यू शुड टेक द पॉइंट्स कैसे लेना. तो सबसे पहले आपके एप्लीकेशन ही यू पहला टाइम टू फाइल रिप्लाई, बिकॉज एट दैट टाइम देयर वाज नो लिमिटेशन कि भाई यू हैव टू फाइल द रिटर्न स्टेटमेंट विद इन 90 days. So we used to be scolded if you file an application for time to file return statement. You are not supposed to take time to file return statement. You have to file some miscellaneous application. 7-11 है, all these aspects should come there. You have to challenge in that. Then compliance is there. better particulars application. Then the figures and words are not there. So all this used to be done.
In documents of registration is not required. Instead of that, memorandum with two witnesses. So what is the authenticity of that memorandum?
Exactly. Now, authentication is there for the purpose of when you are. Now, I can understand what is the legal difficulty. आपल्याकडे एक पक्षकार आलेला आहे, त्याचे आपण डॉक्युमेंट बनवून दिलं, आता तो म्हणे मला याचं नजूल मध्ये याचं फेरफार करून घ्यायचं आहे. That is the practical difficulty. So we will have to take that memorandum, which will be authenticated because there will be signatures of both the parties, and signature will be, we will have to, that document will mention that declaration. I pointed out three aspects: declaration, acceptance, and delivery of possession. So what will that document consist? Again, we are coming about on the point of pleadings, because if you want to, if I say take this piece of paper and draft a hiba, so first aspect will be declaration. So what will that person who's in the property is there, he will declare that I am owner of this property and I declare my intention to give this property to so and so person, and the details and description of these properties are described in the schedule. हा झाला डिक्लेरेशन. त्याच्यानंतर जो दुसरा आहे तो म्हणेल हो मला हे जे आहे मी हे कबूल करतो, आय एम एक्सेप्टिंग दिस अँड आय हॅव रिसीव्ड द पोझिशन ऑफ दिस. हे डॉक्युमेंट झाल्यानंतर तो डॉक्युमेंट आपण नोटराइज करू शकतो आणि मग तो डॉक्युमेंट आपण ऍज अ मेमोरेंडम वी कॅन पुट इट फॉर mutation and everything, and that will be a legal record of that particular transaction.
Sir, custody of minors.
Custody of the minor. Custody of minor in what aspect?
Suppose there are 2-3 marriages and children are there, so you will take the custody.
So that is a difference now. If we are asking about custody of the minor in the case of divorce, obviously that will be with the mother, or that can be an option to, as it is open in other laws, it is optional. It can be with the father with due consent, or with the mother as being the natural, because she can take care. But legal aspect, as I have pointed out, it will be with the natural guardian will be the grandfather in the case of death. If you want, I can point out the exact provision and the wordings also. That is section 359, section 359 of the guardianship is concerned. Again, there is a difference given that who can be the guardian. First is the father, then the executor appointed by the father's will, third the father's father, and the executor appointed by the will of the father's father.
Concept of adoption is there?
No, it is totally alien to the Mohammedan law, and the reason behind is that the parents, you can take care of him, but there cannot be a legal adoption deed executed. He will carry the name of his father. But there are recent rulings. I think there are recent one is of the Supreme Court also, that adoption can be made by the Mohammedan parties also as per the Act. General law, general JJ.
Sir, what is the right in the property of the illegitimate child?
The right will be depending upon his status. Right is there, but depending upon the status. whether his son, daughter.
One question arises.
Yes, sir.
If a child you not adopted, but take care by some person, what about inheritance?
He will not get right. As per the Mohammedan law, he will not get right to it. Because in Mohammedan law, the concept of adoption is alien. Now again, if he is being adopted as per the Special Act, Juvenile Justice Act,
Dana.
त्याच्यानंतरही त्याला राईट भेटणार नाही, बट हिज फादर कॅन प्रोव्हाइड हिम. बिकॉज देर आर टू डिफरंट थिंग्स. आता जसं आहे की क्वेश्चन आला होता, द सन हॅज डाईड बिफोर द फादर, प्री डिसीज्ड, त्याला राईट नाहीये. पण त्या आजोबांनी त्यांना मुलांना पैसे दिले, देऊ शकत नाही असं नाहीये, पण त्यांचा राईट नाही, बिकॉज ही इज द ओनर अँड ही कॅन गिव्ह द प्रॉपर्टी बाय वे ऑफ गिफ्ट अँड एव्हरीथिंग. अँड
क्लास 1 क्लास 2 ची काही कन्सेप्ट आहे लिगल
नाही, शेअर्स आणि याचे आहे ते रेसिपीचे.
फर्स्ट वाईट सध्या ताब्यात येते आणि ते जेव्हा प्रॉपर्टी सध्या प्राप्त झाल्यानंतर दोन किंवा 3 एकर असते. तर जेव्हा प्रॉपर्टीचं विल्हेवाट लावायचं असेल किंवा तो व्यक्ती नसेल तर त्यावेळेस तिच्या लेकरांना अधिकार नाही काय प्रॉपर्टीवर.
The question is what I understood from you. What will be the legal right of the children whose mother has been divorced? The question about that legal right will only arise after the death of the father.
Yes.
Obviously, as children, त्या मुलांचा राईट नाही,
Right.
बायकोचा राहणार नाही, because obviously the marriage has ended.